Next case is case number 526013, matter of Doe versus Cornell University.
May it please the court, my name is Paul Scheckman, and I represent John Doe, the appellant in this case. This case has both, I should say at the outset, I've reserved 2 minutes for rebuttal, Your Honor. This case has both substantive and procedural issues, and I'll start with substance. And the question is, at least as I see it, is this. Should John Doe, an 18-year-old boy, a freshman at Cornell University, have realized that Jane Doe was lacking the ability to choose knowingly to have sex, that's the standard, after he told her he didn't want to have sex because he didn't have a condom, and she encouraged him to continue. She told him she was on birth control, and she had no STIs, and that was because she'd only had one prior boyfriend. So I can put it differently, which is, should he have known that she couldn't consent, a young woman who, as far as he knew, had only had one small cup of beer.
I'm sorry to interrupt, but aren't you simply raising credibility questions for this panel to determine as to what actually happened on during this event?
Well, I am asking the panel to decide what happened, but I don't think I'm asking credibility questions at all. And the reason I say that is a couple-fold. One is his story and hers, except for what was said in that room on the second floor, are very different. And I'm not asking this court to say that he was credible and she was not. I'm relying entirely, right, on her version of events. And second, there really is only one witness who helps Cornell in any way, and that is witness number 4. I think he's wildly inconsistent and not credible. But I'm old enough to know this is an Article 78, and I'm not going to come here and argue credibility.
So how is it that they did not adhere to their own published rules?
Your Honor, that's the second part. I'm happy to go there if you want. And their published rules say this, that unlike some of the other cases this court has had, cross-examination is permissible. It's not permissible in the way it would be in a trial court with the adversary or the adversary's lawyer asking questions, but it's permissible through the panel. And the panel is instructed under the rules that it should ask questions on all topics that are proposed here by John Doe, all topics provided they are relevant and not cumulative, right? And,
but isn't that the point? The question is that you are correctly pointing out the panel determines what questions are relevant. So isn't this a matter of the panel's reasoned judgment as to whether or not a question should be asked? And that seems to be the standard.
But Justice Lynch, there's nothing rational or reasonable about saying, I'm not going to ask any questions about your theory of this case, right? Remember, the theory here is either he sexually assaulted her and she was incapacitated, or he asked, said, I don't want to go further. She said, please do. He continued, and when he walked out of that room, she said to him, why are you leaving? And he responded. So his theory was, at all times, I thought she was in control of her faculties, and she was consenting, she was a willing participant, right? The questions that weren't asked were questions like, when you went to that party that night, right, did you say you wanted to get blackout drunk and have sex with someone? Afterwards, did you keep saying, my boyfriend is cheating on me, right? Did you talk about your boyfriend as you were crying? All of that is his theory of this case.
But let's assume that
which is that she
wanted to get blackout drunk and have sex with somebody, and I think because she broke up with her boyfriend.
That's what I think too.
Let's assume all that is correct, and even that came in. It doesn't take away from the fact of what is the focus. Was she incapacitated at the time that he said that she gave consent?
Look, the only question on the substance here is, was she incapacitated? But more precisely, the question is, what did he think, right? And the question there
So
is...
even if she intentionally got herself that way because she wanted to have sex, how would he know that at the time if she's so drunk?
But she says the following, Your Honor. She says it to the investigator, she says it to the hearing panel. I was confused when I spoke, right? Suggesting there was something in what she said that shouldn't have been taken at face value. Because at face value, this is consent to an 18-year-old and probably to someone older. And so the question is, should he have listened to those words and taken them at face value? And the answer is yes, because that was her intention the entire evening.
But didn't the panel have the right to also look at her actions? And that's why the other witness spoke to her behavior, her ability to walk, her ability to stand, all those other things,
But
which
there's
is
no-
indicative of whether or not she's drunk.
But there's no, well, look, there's no doubt here that she drank, right? And there's no doubt that she passed out. But the real question is, what did this boy think? And there's not a suggestion in this record that she couldn't walk, right? What we know is the following. She walks up these narrow stairs. She gets to the second floor. A boy sees her there and says she seemed completely normal, no red flags. She gets to the third floor where she gets to witness 4, and at best what he says is she didn't seem in the right phase. Now, under oath, he recants all of it. But what he says then is they climbed out this window, and she got out easily. Cornell has this notion that he somehow led her and dragged her out. He got out easily. She then got out easily. She walked down the fire escape, across shards of glass, and into the window on the second floor. They then got into bed. She took her clothes off, right? They got into bed. The conversation happened, right? He then left the room. She said to him, "Why are you leaving?" And he said infelicitously, "Because I came twice," right? And she said the following, "I saw him zip up his fly, right? And I saw that the door was open." So the question for me and for John Doe is, when was she incapacitated? There's no doubt she passed out. But is the notion she was incapacitated as she came down that arduous journey from the third floor to the second floor? Is she incapacitated when she gets in the room and takes all of her clothes off? Is she incapacitated when she responds directly and lucidly to his saying, "I don't want to have sex," right? I mean, we're talking about suspending a boy from college for 2 years with life-destructive consequences. Justice Lynch has recently written about those consequences, and all of us know it.
Are you saying that you have to pass out before someone else can acknowledge
Well-
that you are not in the right state of mind to give consent?
No, but look at how incapacitated is defined.
The fact that she
Uncon-
can take off her clothes doesn't mean that she is as of the right state of mind to be able to give consent.
Look, the standard here is unconscious, asleep, involuntarily restrained, physically helpless, otherwise unable to provide consent. We're all taught words take their meaning from their context. So I'm not saying she's got to be, unconscious when she's having sex, but she is completely conscious. He says to her, "I don't want to have sex. I don't want to have a condom." There's a lot this boy does that night that if it was my son, I wouldn't be proud of. He comes downstairs, he boasts, right? But what happens in that room is something that all of us would want our sons to do, which is to say, right, "I don't want to have sex. I don't have a condom. I'm not protected," right? That's not something we should be doing. And her response is, "Don't worry, right? I am protected, and you're protected too because I don't have STIs." Nothing could be more responsive. And so what Cornell has to say to a preponderance, right, is at that time, that woman was unable to consent, right? Now, you could say the following, right? That time she is, but by the time we're finished, he should recognize that she wasn't, right? She's passive, she's not moving. None of that's true, right? What we know is as he leaves, she's alert. Alert enough to know the door is open, alert enough to see him zip up his fly, alert enough to ask him, why are you leaving, and alert enough to register his response. So the question is, when in this journey is she incapable of consent, and when should he have known it? Because he didn't know it, right? As far as he knew, he had sex with a girl. He comes down, he boasts about it. As I say, that's not my favorite behavior. But he doesn't sort of run out of the house having had sex with an unconscious girl. He thought that this girl had consented and had told him that it was okay to go forward. And the answer is 2 years out of college, a permanent mark on his record, and potentially life-destructive. And I don't think the facts support that.
You want to keep your rebuttal time?
Can I say one more word about your question about the procedure? Because if you want me to, you've taken a fair bit of time this afternoon. I don't want to hold you up.
No, you can.
I would just say again, right? That word in that statute, in that rule, is all relevant, non-cumulative, non-harassing questions, and not to ask her about what were your intentions that night. Why did you keep referring to your boyfriend after this? Right? Why did you just tell someone that you cheated with your boyfriend? That's his theory here. His theory of this case is that he didn't have sex with an unconscious woman, a woman incapable of consent. He had sex with someone who passed out because she drank way too much unbeknownst to him, right? And then, right, after that, regretted it, was embarrassed, said her boyfriend's name as much as she said sorry. And for some reason, Cornell didn't ask those questions. I guess I know why. They're embarrassing questions in the sense of they're pointed, right? They're not questions that one is happy to ask to someone who purports to be a victim, right? But they're questions that, as Judge Fawnin said, they'd be asked in a cross-examination context. This was a cross-examination context, or be it one stage removed. I thank the court, and I thank you for the extra time.
Good afternoon, Your Honors. Valerie Crossdorn for Cornell. Counsel stated that the real question is, what did this boy think on the night of the incident? Counsel told us the answer to that question in his brief on page 2. Doe thought he could have sex without peril on his first night as a student at Cornell University with a girl that he had only just met after they both had been drinking and without protection. He led her to a room that was not his own, in a house that was not his residence, and he had sex more than once. None of these facts are disputed. The record is voluminous, Your Honors.
Well, what about led? You can always throw a word in there that makes the whole thing sound a little different. He led her to do all this. Kind of presumes that he's already guilty, correct?
No, Your Honor, I'm speaking of the visual
He didn't drag
image.
her, did he?
No, he did not drag her. I'm speaking of the visual image reported by witnesses who said Doe was in front, he had the girl's hand, he led her up the stairs, he led her through the window, he turned
Did he
around.
carry her? Did he
No,
have
he
to
did not
pull
carry
her?
her. She walked on her own.
Okay.
So basically, they were holding hands.
Holding hands with him in front of her, yes.
He was leading,
He was leading her, yes.
and there would be nothing unusual about that in any other situation if two people are together and one is leading the other to wherever they want to go.
If you isolate only that visual image from all of the other evidence in the record, correct, Your Honor, there would be nothing unusual about that. However,
What's the evidence, though, prior to them having sex? Isn't her own testimony, doesn't she say that, she said, don't worry about having a condom, I've only had sex with one other person, I don't have any STDs. I mean, prior to having sex, that's somewhat indicative of consent, isn't it? I'm having a problem with preponderance of the evidence that she did not give consent,
Your
or
Honor,
was incapable, excuse me.
Your
was
Honor,
incapable.
this young lady recalled having a conversation about STDs and condoms.
That's a pretty detailed remembrance
It is.
from someone who says they were could not give consent because they were so confused. Correct?
It
Pretty
is.
detailed answer and a pretty detailed remembrance from someone who's very confused.
It is. The expert witness who testified for Mr. Doe explained that sometimes in a partial blackout state, you can have vivid memories of things while still being
But
incapacitated.
what about the detailed explanation part of that as well?
The
You know,
detailed
there's a
ex-
thought process there that goes through, here's 3 good reasons why you don't need a condom.
The detailed explanation comes in part from Doe's testimony, not Roe's testimony. And I would urge the court to review the credibility determinations made by the hearing panel when considering that elaborate discussion of the events. Roe consistently stated that she did recall from the very first interview that she had with the Title IX office that she recalled this discussion. She says she didn't know what it meant, she was confused, and she did not ever say that she affirmatively consented to have
But
sex.
if the listener, if she's saying now that she was confused, but if the listener is hearing that, what he's hearing is that we're having a discussion about sex, we're going to engage in sex, you seem as if you are consenting because you're telling me all the rational reasons why I can go ahead and have sex with you. That's what the listener is hearing, because you're telling me, don't worry about STD, don't worry about anything, I'm okay.
That is correct, Your Honor. She certainly admitted that she said that. No one else was in the room to know what else was going on.
But that's
Your Honor,
her, she said that.
She did say that. Your Honor asked a question earlier about her taking off her clothes. There's no evidence in the record that she took off her clothes. There's evidence that she was found naked afterwards, or semi-naked.
Well, did Doe testify that she took off her clothes?
Doe did testify that she took off her
So how,
clothes.
how can you say there's no evidence in the record that she took off her clothes then?
I'm
What's the state of the
saying that
record? What is the state of the record as to how her clothes came to be off?
Doe's version is the only version in the record. She does not recall how her clothes
So
came
not only
off.
is there evidence in the record of how her clothes came off, it's the only evidence.
It's the only evidence, and again, I urge your honors to look at the credibility determinations made by the hearing panel based on the totality of the evidence. There's a lot of evidence in the record about the state that she was in on the way up the stairs. Counsel referred to witness number 4, saying that he was incredible. The hearing panel found otherwise. The hearing panel found him credible, and his testimony was quite vivid as to her leaning against a door frame, not speaking to him even when he addressed her, asking if she was okay, that Doe was the one pursuing the private room with whatever intentions he had in his mind. There is not any specific reference to sex at that point in time. Doe himself admits that there was no reference to sex until they got to that private
So
room.
I think counselor's argument was about the cross-examination, that had the panel allow these questions, it goes to his whole defense and her state of mind, that she had an intent that night to have sex. And because those questions weren't allowed to be asked, it defeats his whole defense, that this is what the mindset she had, which coupled with the things that she actually confirmed, that she said these things to him about, don't worry about using a condom and all those other things.
Your Honor also correctly noted during my co-counsel's argument that Doe could not have known of that alleged plan at the time of the incident. That is hearsay that came from another witness. The investigative record demonstrates that both Roe and the other participant in the conversation were asked whether this was a plan of Roe's, and she denied that she had any such plan. And the witness number 9 that she was speaking to said, what I got out of the conversation was not that she was going to go, like, try to sleep with somebody. Those two pieces of information were in the evidentiary record. They were considered by the hearing panel. There was no need to ask Roe about something that she had already denied, because as counsel himself acknowledged, the procedures allow for discretion of the hearing chair to not ask questions that are prejudicial or cumulative of other evidence that's in the record. This panel, various judges on this panel have issued decisions in other cases finding that very principle, that you do not need to ask cross-examination type questions when there is other evidence in the record that the hearing panel can consider.
Were there any third-party accounts of Roe's level of intoxication prior to the incident?
Prior to the incident inside the room, yes. Witness number 4 testified that he thought she was drunk when Doe was asking, is there another
For a
room that we
room.
can use? He thought she was drunk. And if a witness who caught glimpses of her leaning against a door frame thought she was drunk, certainly Roe, who was leading her by the hand and turning around and grabbing her other hand and pulling her out the window to get onto the fire escape, should have known that she was drunk.
Well, who defines drunk? Was your witness number 4 some kind of expert?
No, he's a college student, Your Honor.
Was he
Right, but
drinking
at what
also?
point- I mean, drunk can encompass a wide variety of intoxication, a wide array, if you will. So we have a college student's opinion that she was drunk really doesn't go to whether she could consent or not. You could be 0.08 in consent. You could be 1.2 in consent. Both cases, you're drunk. So were there any other witnesses who said she was not drunk?
Counsel referred to another witness who saw her in passing and thought she was fine. So there is a variety of evidence in the record, and the hearing panel
Which
noted
is
that it was
credibility.
particularly challenged to reconcile these two disparate narratives. It engaged in proper decision-making. In fact, it completed its exercise of authority, of discretion, and of responsibility to both students involved in this incident to make findings of fact and determinations of credibility. Its decisions are detailed explicitly in the decision, and the trial court found that that was ample evidence, that there was ample evidence in the record to support those findings of fact and credibility determinations, citing witness number 4, among other resources, including plaintiff's own expert. Roe does not remember the route to the room or climbing down the fire escape. She does remember Doe leading her, holding her hand. She was focusing on the stairs because she was dizzy. Her testimony is also in the record, and Doe would have this court ignore everything that she said. While he stated here in his oral argument that he is relying entirely on Roe's versions of events, he is not, because he is ignoring every piece of information that doesn't fit the story that he wants this court to believe, which is not the story that the hearing panel found and not the story that the trial court found ample evidence in the record to support. Thank you, Your Honor.
I have 2 minutes, and I'm going to try to go very fast. The argument began by saying that he thought he could proceed without his pearl. They were both drinking, and he had this sex without protection. Be aware, he thought he could proceed without his pearl because she told him he could. They were both drinking, except he didn't know that she had anything else but a cup of beer. The reason this sex was without protection was because she told him it was with protection. So that's not a very powerful opening argument, since all those things are rebutted by the words she said in that room. We get a lot of this, she led him by the hand, and there's just not in the record. What's in the record, the only thing in the record, is that witness 4 says he helped her out of the room. He says they got out easily, right? She doesn't remember that journey, but that's the only journey you could take. That's the only way from that room to the second floor. And it requires going down a staircase, over shards of glass, and climbing into the next room. And the expert says, boy, it's hard to imagine anybody doing that if you're incapacitated. It's easy to imagine somebody, and the scientific literature is replete with examples of doing it if you're blacked out. Because blackout is not what I thought it meant when I started this case. It just means you're not forming memory. But what that expert says is it's hard to imagine anybody incapacitated taking that route, right? Witness 4, I'll just be quick. Here's what he
Was
said.
there any evidence that he was drinking?
Yes. She did, I don't think she knew it because it was mostly before. The expert puts him at about 1.2, right? Not intoxicated lawfully, but certainly not incapacitated. He was 1.2. Here's what witness 4 says. She seemed like fine. It was pretty much a gray area. I asked if she was okay. She walked away. From the little words she spoke, she was slurring them. She was leaning on the wall to catch her balance, or because she was tired, she didn't seem in the right phase. None of that gets you remotely incapacitated. And that is the only...
But that's a perception to someone else who was also drinking.
I was very intoxicated, is what that witness says. Now, and I don't think that particularly helps Cornell, because a fellow who was very intoxicated, right, based on a little bit, thinks she may be drunk. And mind you, when he gets to the hearing and he's sober and he's under oath and he has no relationship to this boy whatsoever, he says, look, I don't know, maybe I thought she was drunk because she was leaning, right? I didn't hear her slur. I didn't pay much attention to any of it. I was talking to my friends. That's the only witness in this case. And the question is exactly the question that Justice Devine asked, which is you have to say to yourself, can a rational person find this to a preponderance, right? There are a lot of people in this country who think that standard's too low given the consequences here. But it is still a standard that we all know. And the question is, could a rational person find this to a preponderance based on two things? The fact that she's passed out afterwards, which tells us nothing, right? And witness 4, who tells us little.
That was my question. Most of the witnesses who testified to the passing out, putting a backpack on her so she didn't roll over, most of the witnesses as to any incapacity are
Ex post. Just
sex.
right. Just right. And the witnesses on the way up, other than witness 4, is witness 3, who's one floor below. And he says, I didn't see any red flags. They seem perfectly normal. They look like two people looking for a room, right? And the witness down at the beer pong game, who says they weren't drunk, she was happy drunk, but seemed fine, right? Again, Justice Devine, it's not right for you to make my arguments, but you said she said 3 things that gave him the green light. And she did, right? And each of them was responsive to what he said. And so you have to say to yourself, unless this woman became, right, incapacitated during, right, we know from those words that she wasn't incapacitated at the outset, or at least he had no reason to think she was. He hadn't seen her drinking, right? And so we know, so the question is, did she become incapacitated during? And we know that when he left that room, she was awake, right? She was competent. She said to him, why are you leaving? She heard his answer. She knew the door was open. She saw him zip up his fly. So the question is there anything that happened during that encounter that should have said to him, it's not where we were when we started? And there's a total void in the record. I think there's a total void in the record because there's no there. But be that as it may, there's a total void in that record. And if what this court has to find is a preponderance of the evidence that a rational person could have concluded to a preponderance, right, that he knew she lacked the ability to choose knowingly to have sex, I don't think you can do it on this record. And again, I repeat what I think is so obvious. The Court of Appeals has said it. Justice Lynch has said it. The federal circuits have said it, right? This is not trivial. This is not a decision that academics are used to making, right? Our Court of Appeals has said in Tedeschi, when you get this kind of case, even that arbitrary and capricious standard should have some teeth, because the standard is, the consequences are so severe. And so I ask you, look at that record again and say to yourself, if she consented at the outset, right? If he thought she consented at the outset, what changed? And I don't think anything did, and I thank the court.
Thank you both.
All rise.